We are following breaking news out of the Supreme Court that justices have agreed to decide whether former President Trump is entitled to immunity from federal prosecution in the 2020 election case. I want to bring in Major Garrett, who, of course, is our chief Washington correspondent. Major, good to see you. I know we've been waiting for this decision. Your takeaways on the Supreme Court deciding that they will hear Trump's immunity plea?
It is an important constitutional matter, one the court has never had to consider because no former president has ever been prosecuted or, in the terms of that prosecution, asserted to this highest court in the land that every activity undertaken during a presidency is absolutely immune from any second guessing or criminal prosecution federally. These are issues we've never had to grapple with. And the simple reason we're having to grapple with these is because the former president, while president of the United States, wouldn't accept the results of the 2020 election, lied about them relentlessly, and undertook an effort, which is now subject to federal prosecution, to overturn that election. We are here because of the actions and decisions undertaken about the 2020 election by the former president. We're not here for any other reason than that. And it is an important constitutional question, but it's being asked in a way that is in the backdrop of January 6th, an assault on the U.S. Capitol to delay the peaceful transfer of power because on that day we were to certify the electoral vote sent in legally and in a binding way by every state in the union. That, yes, all of this is extraordinary, but we cannot overlook why it is extraordinary. The singular act of a president to not accept the results of a legal, verified election and to deny his likely successor, his certified successor, his place in the American presidency through a peaceful transfer of power. That is why we are here. So yes, it's an important constitutional question. The Supreme Court had a big choice. Does the Supreme Court take the rulings of a district court and an appellate court as the final word? I think it understood that popular perception of the Supreme Court is wavering, to put it gently. And because 3 of the justices sitting on this court were appointed under the Trump presidency, this court wanted to make sure this decision was reflective of the court that in some ways Trump created. So if it's negative against the former president, it's emphatic by his own hand-picked justices. No, you don't enjoy this absolute immunity, and you're going to have to go to trial. But the timing is astonishing. If there's a trial, Caitlin, as was just discussed in the special report, it will collide with the Republican National Convention in Michigan. It may bleed over to the Democratic National Convention in August in Chicago. And as we are living through this history, we are going to have to ask ourselves relentlessly, why did the Attorney General of the United States, Merrick Garland, wait so long to set in motion or to give the signal that a prosecution of this former president over January 6th and everything related to the 2020 election waited so long? Why? This collision is in part because of signals sent by the Justice Department. And it is colliding with the presidential election in a way that will test this country, its laws, its institutions, and its politics as never tested before.
Yeah, I know we throw around the word unprecedented, but this is very true in this case, of course, and the way in which this has become a courtroom campaign for...
It is, I think a better terminology is breathtaking. It will take the breath away of this country.
On the timeline, I want to bring in former Deputy Assistant Attorney General Tom Dupree, who joins us now. Tom, I thank you for being here. I want to get your thoughts on what Major just mentioned here, was just talking about here, the way in which the decision by Merrick Garland to take his time here in making a decision. What kind of impact has that had?
It has had a massive impact, and it will continue to have a massive impact as this whole saga plays out over the course of the summer. It's always been a little peculiar as to why the Justice Department and Merrick Garland waited so long to spur this prosecution on, to bring the charges, and to begin with this, because they knew that delays happen in criminal trials for one reason or another, particularly in a case of this magnitude. It was virtually certain that former President Trump would make an immunity defense, that immunity defense would then get litigated up through the courts of appeals, possibly to the Supreme Court, All the while, the trial court proceedings were put on hold. So they knew this was a possibility. And the fact that they didn't bring these charges until, a year or so, plus or minus, before the election meant that they were acting on a very tight timetable with virtually no margin for error. And now we're seeing as it's playing out, I think everything's going to be put in a very difficult position. Once the Supreme Court decides, it's going to be May or June at the earliest. And then the Justice Department will face the question as to whether they do want to push for a trial date before the election during the convention and during all the political windup.
And Tom, there is a set of guidelines within the Justice Department about decisions, both to prosecute, meaning to bring charges, or to press ahead as it relates to an election calendar. What are those guidelines, and how do you think they will manifest in this enormously public and consequential decision once the Supreme Court does issue a ruling?
Sure. The guidelines are a little bit hazy. The basic rule is that the Justice Department never wants to take action, and that would include bringing people to trial, filing charges close to an election in a way that potentially could influence the election. But it's not as though there's a specific calendar date in the Justice Department manual that says thou shalt not charge after such and such a date. It's a question of judgment. But here, it seems almost impossible to think that they could try to fit in a trial before you get into the full-on political season. As I said a minute ago, the Supreme Court is not going to decide this case until May at the earliest, and quite possibly not until June. There will then need to be at least a month or 2 or maybe 3 months of preparations in the trial court before you can begin the trial. You have to have pre-trial motions. You have to select a jury. There are all sorts of things that go into getting a case ready for trial. So by the time you're looking at the actual trial beginning, you're kind of talking early fall, which is, again, right in the heart of the political seasons. I think this would be a very difficult decision for the Justice Department to decide whether they still want to proceed with a trial before the election.
Yeah, I was going to ask you about that, too, because what kind of impact does this have on the underlying case here?
Yeah, well, the underlying case is going to remain apparently in a state of suspended animation until the Supreme Court decides whether former President Trump has immunity. If they decide that, well, he does have immunity, the case disappears. If, however, they decide that he does not have immunity, well, then presumably the engines will immediately restart in the district court. And there you're going to have that 2 to 3 to 4 month run up to a trial where the lawyers are racing around. They're getting their evidence ready. They're getting their witnesses ready. They're getting their trial preparations ready for what probably will be the trial of the century. Can't happen overnight. So you're just looking at a system that already builds in that several month process and pushes us right up until the cusp of the election.
Tom, could you evaluate for the audience the merits of the former president's assertion made by his attorneys to the court that absolute immunity is a real thing and should be basically accepted by the Supreme Court as an orientation toward not only power, but separation of powers?
It's a very, very aggressive argument. Certainly no court has ever accepted this argument before, this broad scope of immunity that former President Trump is claiming. I think that the government has a very good counter argument that recognizing immunity of this nature would threaten the separation of powers, that it would threaten our constitutional structure, and that it would elevate the president above the law. And the hypothetical you all remember from the appeals court argument where they said, well, if former President Trump is right, that presidents are absolutely immune, could a president order SEAL Team 6 to kill his opponent? Clearly, the answer to that is no. But that's a very difficult aspect for the former president in making this argument and trying to persuade the Supreme Court to go where it's never gone before and broaden and expand the scope of presidential immunity to encompass anything that the president does while he's serving in office.
And Major, I want to ask you a political question, which is, given what Tom said about what this does to the underlying case, I mean, the strategy from the Trump team has been to try to delay this as much as possible, right?
Yeah.
I mean, this is part of a bigger play here.
I mean, I'll leave it to Tom on the legal side of it, but just the jousting and the politics of the jousting in which the former president almost always finds himself on the better end of the spectrum, this is a victory. Any delay is a victory. Any delay, even by a day or two, is a victory. And this is not a day or two.
Right.
As we've laid out, this is several months. And the complications of having all of the former president's due process rights protected, as Tom laid out, they inevitably must be protected. In a high-profile case like this, all due process rights must be protected, but especially if the litigant is a former president of the United States, every benefit of the doubt is going to go to that particular high-profile defendant. The Trump team has known that from a legal strategic point of view, Every delay adjures to his benefit, not just legally, but politically. And now this case, if it follows the timeline that we have laid out, it seems almost impossible to carry out in the heat, the white-hot heat of a 2024 presidential campaign.
Exactly. Major Garrett, stick with us. And Tom Dupree, thank you very much for your time. We really appreciate your analysis here. I do want to bring in CBS News campaign reporter Katrina Kaufman joining us now. She's also an attorney. I know, Katrina, you have been covering all of the Trump cases here. So can you kind of put this into context for our viewers here who are often faced with the challenge of trying to keep track of everything going on the legal front for Donald Trump? We were just talking with Major and Tom about kind of the timeline here and how this collides with other cases that Trump may be facing, and of course with the underlying January 6th case. But what other cases are kind of on the horizon, and does this interfere with any of those?
Hi, Caitlin. So yes, we have coming up the first criminal trial that's going to be prosecuted against Trump, which is the hush money case here in New York. That's going to be March 25th. And originally, this D.C. trial was supposed to be in early March. It was scheduled for March 4th. But what's happened with this immunity issue has just pushed that, as we see. And now, by my calculations, I think that case probably couldn't start until September if the Supreme Court allows it to go ahead. And that could actually put it in conflict with the Georgia case, because Fani Willis was looking to have that start on August 5th. So that would potentially put these two trials in conflict. There's a lot of stuff going on with Fulton County as well to see how that case is going to proceed. But that's what comes to mind first when I think about the intersection of these cases at this moment.
And Katrina, I know we're kind of every day on watch for some kind of decision here, but I'm curious too about your general takeaways from the Supreme Court deciding to take up this case.
I was a bit surprised. I think the fact that it took them so long to make a decision about this, I was under the impression that perhaps they were going to deny it. Someone was writing an opinion, but it looks like the Supreme Court wants to weigh in on this, and it makes a lot of sense. This is an issue of first impression. It's a major constitutional issue, and the Supreme Court really should consider it.
Katrina, thank you very much. Major, I do want to talk. Oh, can I? Okay, thank you. We're rolling here. I do want to talk just a little bit again about the politics here, because we've both been on the campaign trail a lot over the past several months.
Right.
And when you go to rallies for the former president, when you talk to voters, this is very much on their minds in terms of them lumping together all of those cases that Katrina just described and trying to cast everything as political. And to your point about the strategy involved on the legal front being a political strategy too, the way in which this has not only endeared his supporters to him, but has, you know, kind of, the more information comes out, the more they feel impassioned for him.
And let's just focus on the January 6th case, this particular case, because this is what the Supreme Court is being asked to decide, only in the context of this case. This is not a decision that has any bearing on the documents case or any other, only on January 6th. And you know this and I know this, but I want to share it with our audience because it's very important to understand the underlying politics and Trump's relationship to his supporters. They look at this and say the following. The Justice Department didn't do anything. Then the January 6th Select Committee, which many Trump supporters regard as a partisan maneuver. Two Republicans who are anti-Trump on that committee working with Democrats did this investigation, which they regard as kind of an elaborate TV program meant to get the former president. I'm not validating any of this, but this is how they view it. And then the January 6th Committee makes its recommendations, and then and only then, according to Trump supporters, does the Justice Department kick in gear. So the way they digest that is Nancy Pelosi created a committee filled with hard Democrats and two anti-Trump Republicans, produced evidence and a report, and then and only then. So it's basically Nancy Pelosi kicking this over to the democratically led Justice Department under Joe Biden, who brings these charges, and that's why we're here. Skipping over entirely what Trump did and lies about the 2020 election. This is why for this case, which is a super important case, not just this defendant, the former president, but the American presidency, Trump supporters just see it as another partisan maneuver. And that story That narrative for themselves doesn't budge. You've heard it. I've heard it. And you have all these other intervening factors, the Supreme Court and legal appeals, and all, they've already decided this. Right. And so now they look, hey, this trial could be right up again, or maybe not even held at all. See, our guy wins again, no matter what. They can't get him. No matter what they do, they can't get him because he's smart enough, tactical enough, he can maneuver around it, and we're going to have the election on our terms. That's how, I guarantee you, that's how this is being interpreted moment by moment this afternoon across the country and among those who are Trump-supporting Republicans. A lot of other Americans will look at this and say, wow, Supreme Court could have read that 57-page appeals court ruling and said, you know what, they got it right. The law, every underlying case, all precedent, all history, done. Ms. Former President, you don't have it. And they could have made that determination several weeks ago. But no, the weeks and weeks and go on. Now they say, no, we're going to weigh in. And they have to know they are not immune from the larger political conversation in this country. Supreme Court knows by waiting this long and now pushing into April, they've made this trial, however it decides, almost untriable in this calendar year. Not impossible, but very difficult. And even if it is held, it will reinforce all of these underlying things we've talked about, suspicions, aggressions, grievances, the Trump supporters and the Trump legal team and the former president himself not only has, but will continue to have about this particular case.
And a lot of those sentiments have been fostered by Republican rivals who have not criticized Trump on this at all and kind of helped to create that scenario as well.
And look, there are plenty of fair-minded Republicans who say, you know, maybe this particular question about what the former president did in office and January 6th is best handled by the next election in a political context only. Don't prosecute him over it. Let's see that he's defeated for a bid for re-election, and that would end it. That is an interpretation that even some Republicans who are not adoring of the former president hold. But that ship has sailed. This is a prosecuted case. He's indicted. The Supreme Court will decide whether or not he or any future occupant of this office has absolute immunity or not. But even if it decides you don't, and you've got to go to trial, the practical schedule of that trial now is enmeshed with the presidential campaign, and therefore may not go ahead.
Collision course indeed. Major Garrett, as always, thank you very much for sticking with